Dear friends, today I am going to talk about Section 2CP of Factories Act, which talks about to notify to the authority about the cause of the material which is dangerous to the health of the workers. This section, that is 41A, that is in chapter 4A, has inserted in the year 1987. This section was inserted after global strategy. The appraisal committee has been set up, and later that this section has inserted. And this section very well talks about compulsory disclosure of material which is injurious to the health of the worker to the respective authority, that is factory authority under the Factories Act. And also this section talks about the wearing of personal protective equipments and the necessary training about the material, how to handle the material, how to transport the material, all these things to be given to the handling the material by the workers, and how to use those material into the machines, and how the emergency preparedness, that is emergency response teams, which works under the Factories Act. And this also discussed in the many of the case laws. That is, when we are reading from MC Mehta versus Union of India under the doctrine of strict liability, because there is no vicarious liability or any other escapism under any route. The employer is held responsible, that is, occupier of the factory is held responsible if at all any violation under section 41A, that is section 2CB of Factories Act. Under that, the doctrine of strict liability, the employer is held liable when any injury or fatal incident happened because of using this chemical substance. And another doctrine, that is another principle, polluter pay principle from one among the case, that is also dealt under the section 2CB of Factories Act. And also in one case law, protecting of human rights is the responsibility of the employer. So all we should know about the health of the worker. Thank you. I will meet you once again with another presentation. Please subscribe to Murali HR.